Judgment in the appeal of the Rugby Football Union against Consolidated Information Services Limited.
Lord Kerr will give the judgment.
There are occasions when someone believes that their legal right has been infringed and when they wish to do something about it, but they are unable to do so because they do not have the necessary information, such as the identity of the wrongdoer. If they are able to identify someone else who, whether willingly or otherwise, facilitated the wrongdoing, they may, in certain circumstances, require that other person to give them full information, including the identity of the actual wrongdoers. Where that other person refuses to disclose the information, an application may be made to the court for an order requiring him to do so. Such an order is commonly known as a Norwich Pharmacal Order, so called because of the name of the case in which this principle was recognised. The right to obtain the information is not automatic. An order for disclosure will only be made where it is shown to be necessary and proportionate. The court will take into account a number of factors in deciding whether it is necessary and proportionate to grant the order. These include an assessment of the strength of the case, that there has indeed been wrongdoing. They also include the possible claims to privacy of those whose identities will be disclosed. That consideration has been given particular emphasis by Article 8 of the Charter of Fundamental Rights of the European Union. This guarantees the protection of personal data. The Rugby Football Union distributes to various outlets tickets for rugby matches at Twickenham Stadium. Those tickets may be sold, but it is a strict term of the agreement on which the tickets are supplied that they should not be sold at greater than their face value. In the run-up to the international rugby matches in autumn 2010 and the Six Nations tournament, the RFU discovered that on a website operated by a firm called Viagogo, thousands of tickets for these matches were being offered for sale. They were offered for sale above face value, in some cases at many times face value. The RFU wanted to find out who was offering these tickets for sale. It asked Viagogo to supply the information. Viagogo refused to give it. The RFU applied to the High Court for a Norwich Pharmacal Order. That was granted. Viagogo appealed. The Court of Appeal dismissed their appeal, and Viagogo appealed to this court. It argued that in deciding whether it was proportionate to make a Norwich Pharmacal Order, the court, particularly in light of Article 8 of the Charter, should consider whether obtaining information about a particular person who had sold a ticket at more than face value would benefit the RFU to an extent that outweighed that individual's right to have his or her personal data protected from disclosure. It was Viagogo's contention that in making that assessment, the court must conduct the examination solely by reference to the particular benefit that obtaining the information relating to an individual data subject might bring. Its value, as part of a broader context, was not to be considered. By its judgment, this court unanimously rejects that argument and dismisses the appeal. Of course, the facts of each case must be considered, but this does not mean that they should be placed in a hermetically sealed compartment so that their possible impact on issues going well beyond their significance to the person whose personal data are sought is ignored. There is no logical or sensible reason to disregard the wider context in which the RFU wants to have access to this information. The ability to demonstrate that those who contemplate such sale or purchase can be detected is a perfectly legitimate aspiration, justifying the disclosure of the information sought. There is no reason that it should not feature in any assessment of the proportionality of the granting of the order. The parties shall have 28 days within which to make submissions on costs, if, that is, after considering the judgment, they conclude that they must make representations on that matter. Submissions on costs are in no sense obligatory, so far as this court is concerned.